Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the realm of international taxation. For today's episode, we have selected three important cases. The first one discusses the taxability of interest on loans guaranteed by foreign banks. The second one discusses the stipulation of authority to conclude contract for concluding existence of agency PE. And the third one discusses the treatment of exchange of information between expatriates as existence of PE. Let us now proceed to our first case. After the huge Vodafone saga, the telecom industry is back in the news, and this time it's Bharti Airtel. The first case in this episode revolves around taxability of interest on loans guaranteed by foreign banks to Indian telecom service provider for purpose of buying telecom equipment overseas. Let's understand what exactly happened in this case.
The SSC in the present case desired to purchase telecom equipments from a Swedish supplier, Ericsson, which required substantial funding in foreign currency. In furtherance of the same, the SSC entered into a facility agreement with ABN AMRO Bank, Scotland branch, wherein the term loan was guaranteed by the Swedish Export Credit Guarantee Board, which had been set up by the Swedish government. While making payments to ABN AMRO Bank, the SSC did not withhold any TDS under the belief that it was not liable to tax in India, having regard to the provision of Article 11(3) of the Indian-Sweden DTA. The AO, however, initiated proceedings under Section 201, subsection 1 of non-withholding of tax from the payments made in ABN AMRO Bank, disregarding the fact that the Swedish tax authority had issued tax residency certificate, certifying that ABN AMRO Bank was a tax resident of Sweden in terms of Indo-Sweden DTA.
Now let's see what the tribunal finally decided. Non-resident recipient, which is mainly acting as a conduit, cannot be construed as benefit owner without examining financial arrangement between the original lender and the debtor. Interest on loans guaranteed by foreign banks have to be taxed in the hands of the beneficial owners of such interest only and not any conduit receiver. Let us now proceed to our next case. Moving to our second case, the High Court was approached to decide on as to whether the nature of business activity or authority to conclude contract is indispensable for concluding fixed place or dependent agent PE of the non-resident entity in India. Let's understand what exactly happened in this case. The SSC in the present case is a tax resident of the USA and is primarily engaged in manufacture and offshore sale of equipment. The Indian arm of the SSC, that is GEIIPL, was a party to the Global Service Agreement with its international operations arm, namely GEIOC. In consideration, GEIIPL received remuneration on cost plus basis, which was assessed to income tax and also subjected to ALP determination by the TPO, who held that the transaction with its AE was at arm's length. Besides, GEIOC maintained a liaison office in India designed to act as a communication channel only, and they did not carry any business activity in India. It had several employees on its payroll, and they were deputed to various companies in the entire group. GEIOC did not file its returns. In the meanwhile, its premises were subject to survey proceedings. It was found that GEIOC's liaison office was operating in India by sending its employees on assignments to GE entities located worldwide. Though the SSC resisted the move of the AO to assess them, contending that they were not subjected to income tax laws of India as they had no PE in India, however, rejecting those contentions, the department held that the SSC had a PE in India. The AO also deemed 10% of the value of supplies made to the clients in India as the profits arising from such supplies and attributed 35% of such profit to the SSC's PE in India. This was attribution of profit was reduced to 26% by the appellate tribunal.
Here is the final verdict of High Court. If liaison office, that is LO, was not just for mute data collection and information dissemination but played vital role in finalizing commercial terms, is to be concluded that non-resident has carried on business in India through its fixed place PE. Even if the LO or the Indian subsidiary had no authority to conclude contracts, but its activities were vital per se for realization of profits, it is to be held as PE in India. The fact that transaction between an agent of dependent status and multiple related enterprise are at ALP or not is not relevant at the stage of establishment of a dependent agent PE in India. OECD commentary can only be used as guidance and it does not form a part of a treaty under doctrine of incorporation.
Let us now proceed to our final case, in which the exchange of information between two expatriates was construed as permanent establishment. Let's see what exactly happened in this case. The SSE company is a tax resident of South Korea, having two wholly owned subsidiaries in India, namely CL and CISO. During the relevant year, the SSE company established a project office in India for carrying out activities required in pursuance of the contract entered with CL for providing technical support assistance in relation to systems used in the operation of LTE networks. However, the operations came to a standstill. Meanwhile, survey proceedings were conducted at the premises of CL, and the SSE's case was that the seconded employees worked under the supervision and control of CL, which was the real economic employer, and hence it could not be held that SSE had a PE in India in the form of expatriate employees. Rejecting the submissions of the SSE, the AO held that the SSE had a fixed place PE in the form of expatriates.
Now let's see what the High Court had finally decided. When benefits derived by Indian subsidiary by communication received from expatriates are offered to tax in India, then such communication activities of expatriate employees can be construed as mere reporting required in course of discharge of functions of subsidiary company towards holding company. Mere exchange of information between Indian subsidiary and expatriates in furtherance of market strategies will not render such expats as PE if no business activity was carried out through these expats.
With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube for our upcoming videos. Please also feel free to share your views with us at editor@tiol.in. Thank you for watching and have a nice day.